This is part 2 of our discussion of Model Rule 5.5. And here we're going to be talking about sections D and E of the rule, which the ABA calls multi-jurisdictional practice or multi-jurisdictional practice of law. Let's take a look at the rule and see what we're talking about here. (5.5) A lawyer admitted in another United States jurisdiction or in a foreign jurisdiction and not disbarred or suspended from practice in any jurisdiction or the equivalent thereof may provide legal services through an office or other systematic and continuous presence in this jurisdiction. So notice we're using very similar language to an earlier section of the rule about what would definitely count as practicing law. And we're really going to have two sections here that are special provisions for where you could just set up shop and provide legal services long-term in another state where you are not licensed. Number one, and I'm going to call this the in-house corporate counsel exception. These are services provided to the lawyer's employer or its organizational affiliates and are not services for which the forum requires pro hoc vici admission, and when performed by a foreign lawyer and requires advice on the law of this or another U.S. jurisdiction or of the United States, such advice shall be based upon the advice of a lawyer who is duly licensed and authorized by the jurisdiction to provide such advice. So just a moment, let's take a break and talk about what we're saying here. So let's say I'm going to give you a few scenarios. We're really talking about being in-house counsel at a big corporation. And we're not talking about going to court or litigating on behalf of your client. You're not going to be filing appearances because that would require pro hoc vici, which this rule says it's not covering. You would have to do that separately. So this is the in-house lawyer who's advising people in the company, reviewing contracts, and supervising outside lawyers that they've outsourced litigation to. So I'm going to give you a couple of examples, 2 or 3 examples very quickly. Let's say insurance companies, big national insurance companies employ a lot of lawyers in-house, and you could be hired by an insurance company in another state apart from the one where you're licensed. So you could be licensed in Texas, but get a job in St. Louis in-house with a big insurance company, or Hartford, Connecticut, with the insurance capital of the world, and do legal work for them and not have to get admitted there. Now, please note, you're not going to be able to like moonlight and do start representing other local clients and so forth. And if a question of local state law comes up, you're going to have to ask local counsel or double check with local counsel. Second example, the airlines. So United Airlines is a big national carrier and they have corporate offices in Houston and in Chicago. So let's say you get licensed in Texas, you start out in the Houston legal department at United Airlines, and they want to relocate you to their Chicago offices and have you work there. That's great, and actually you don't have to get admitted in Illinois because you're only representing one client, right? You're not going to be representing other people, you're not going to be doing court appearances and so forth. You're still in-house for the same multi-jurisdictional client. This can also apply to international lawyers or lawyers from foreign countries. So here's an example. British Petroleum, or BP, has offices in Houston. And it would be very reasonable for BP to want to have some UK lawyers from their home country where the company is based, here in their Houston office to advise on matters of UK law or international law. And that's fine, and they don't have to get licensed here. But the day a question comes up about Texas law or federal United States law, they need to have either an American lawyer, someone licensed in this jurisdiction in-house or outside that they can double check things with. Petrobras, the national oil company of Brazil, has office suites in Houston on the west side of town. It would be entirely reasonable for them to have some Brazilian lawyers who are not licensed here in their offices to advise about Brazilian law and employment law and things like that, and international law, import exports and so forth. But if a question comes up about Texas law or US law, then they need to double check with someone who is actually licensed here. So that's what this first provision is talking about. Two, these are services that the lawyer is authorized by federal or other law or rule, in other words, regulations, to provide in this jurisdiction. And I call this the exclusive federal practice exception. So just to make sure you understand, we have a few federal agencies, immigration agencies, Social Security Administration, the US Patent and Trademark Office, and the Veterans Administration. Those are the big examples. There may be minor ones that I'm not aware of. And each of those ones I've mentioned have either a statutory provision or a regulatory provision that allows non-lawyer advocates to represent individuals who are appearing in matters before that agency or who need to file petitions with that agency and so forth. And that is okay. So first of all, those non-lawyers can do it. And you, if you are a lawyer in one state, could do this work in another state as long as it's confined to practice exclusively to practice before that federal agency that comes under the regulation or statute. This, by the way, this provision was mandated by the a US Supreme Court case that I'm going to talk about in a minute, decades ago. E relates to section D. For purposes of paragraph D, so remember that's our in-house counsel rule or our kind of exclusive federal agency practice rule, the foreign lawyer must be a member in good standing of a recognized legal profession in a foreign jurisdiction. So here we're talking about lawyers from other countries primarily under 5.5E. The members of which are admitted to practice as lawyers or counselors at law or the equivalent and are subject to effective regulation and discipline by a duly constituted professional body or a public authority. Of course, you've probably heard that in some of the other common law countries, we don't just call people lawyers, we call some of them barristers and some solicitors and so forth. We're not hung up on the terminology here. What we're concerned about is that this country has some system for licensing lawyers. They don't just let everybody call themselves a lawyer if they want to be. And they have some system for holding people accountable for ethical violations and so forth. And so if it's a country with no rules or a country that's a failed state, right? They don't have a functional central government because of a civil war or something like that. So there's no one really controlling or regulating the legal profession anymore, then that's not going to count. Those are rare exceptions. Most of the time, if you are a lawyer in good standing or the equivalent in your home country, this is going to apply. Now, we have this case that I mentioned in a moment ago. This is Sperry versus Florida from 1963. Now, for my students, you will not need to know this case by name. You don't need to know the case name on the MPRE or on my exam. But you could see a question, a fact pattern that's based on the facts in this case that asks you about the holding or the rationale. And so you don't have to know this case, but hear me out about it. This was a non-lawyer named Sperry who was working as a patent agent in Florida in the early 1960s. Everything he did, it was exclusively before the US Patent Office. So he was doing patent applications and so forth. The Florida State Bar charged him with the unauthorized practice of law. And in fact, the US Supreme Court admitted that this would normally be the practice of law. This is something that lawyers normally would do. And for any other government agency, normally this would count as the practice of law, and you need to have a law license to do this on behalf of other people. The problem is that patent regulations expressly permitted non-lawyers to do these tasks pursuant to the relevant enabling statute. And so the Supreme Court relied on the supremacy clause. And so that's one of your takeaways from this, is that the supremacy clause says that if there's a federal statute or regulation that authorizes non-lawyers to do certain types of legal work just be confined to that agency, they can do that. Now, the Supreme Court said Please note, Sperry's not allowed to start doing their divorces or handling their child custody matters or drafting wills or things like that. But Sperry was being careful, and all of Sperry's work was just doing patent work before the Patent and Trademark Office. And so basically, the states must yield to federal regs and statutes, and our examples, again, of the agencies where this is most likely to come up are the Patent and Trademark Office, the Social Security Administration, the Veterans Administration, and both of those, and the INS, or Immigration, and all of these agencies have lots of hearings and so forth where we might represent people. Okay, we have one comment that I want to talk about. As I mentioned in the first video for 5.5, most of the comments for 5.5 merely restate provisions of the rule. You should read through them once to clarify your understanding of the rule and to help you remember the rule provisions. But this comment actually clarifies something that could be the basis of a test question or a standalone rule. A lawyer who practices law in this jurisdiction pursuant to paragraph C or D, so that's the kind of exceptions from either the last video where we talked about pro hoc vici or appearances or incidental travel to other states on behalf of a client, or here, in-house counsel for a corporation, or this exclusive federal practice exception. You are otherwise subject to the disciplinary authority of this jurisdiction. Now, we're going to talk about this again later in the course when we get to Model Rule 8.5. But what we're really saying here is, even if you are in another state doing something and what you're doing is permissible under this rule, if you violate the other legal ethics rules in that state, you could face consequences. You could be subject to discipline in that state. And as a matter of fact, your home state where you're actually licensed could also discipline you for what you do out of state. So if you do a pro hoc vici appearance in another state and you violate some ethics rules while you're there, that state can hold you accountable, and your home state could hold you accountable too. Again, we're going to revisit this issue later in the course, but it comes up in the comment here, and I want to preview this for you. The fact that you're not licensed in a state, you're still kind of obligated to comply with the other ethical rules of that state while you're doing legal activities there, if you're availing yourself of the provisions or the exceptions or the carve-outs that are under this rule. That concludes our lectures for Model Rule 5.5.